Conciliation Officer. A conciliation officer is a government representative to solve the industrial disputes. He is a mediator and his duty is to mediate in and promote the settlement of industrial disputes. Duty of conciliation officer is administrative and not judicial. He is not having any power to impose any order to the parties concerned. A conciliation officer may be appointed for a specified area or for a specified industries in specified area either permanently or for a limited period. Powers of Conciliation Officer. Section 11 of the Industrial Dispute Act lays down the powers of the conciliation officer. Conciliation officer, for the purpose of inquiring into an existing apprehended industrial dispute, is empowered after giving the notice to enter the premises occupied by the industrial establishment. He is also empowered to call for and inspect any document which he may consider relevant to the dispute. He enjoys the same powers as are available to the civil courts. All conciliation officers are public servants. Duties of a conciliation officer. Section 12 of Industrial Dispute Act lays down the duties. Where any industrial dispute exists or is apprehended, the conciliation officer may, or where the dispute relates to public utility service and a notice under Section 22 has been given, shall hold conciliation proceedings in the prescribed manner. The conciliation officer shall, for the purpose of bringing about a settlement of the dispute without delay, investigate the dispute and all matters affecting the merits and right settlement thereof, and may do all such things as he thinks fit for the purpose of inducing the parties to come to a fair and amicable settlement of the dispute. If no such settlement is arrived at, the conciliation officer shall, as soon as practicable after the close of the investigation, send to the appropriate government a full report setting forth the steps taken by him for ascertaining the facts and circumstances relating to the dispute and for bringing about a settlement thereof, together with a full statement of such facts and circumstances and the reasons on account of which, in his opinion, a settlement could not be arrived at. If on consideration of the report, the appropriate government is satisfied that there is a case for reference to a board, labor court, tribunal or national tribunal, it may make such reference. Where the appropriate government does not make such reference, it shall record and communicate to the parties concerned its reasons therefor. A report under this section shall be submitted within 14 days of the commencement of the conciliation proceedings or within such shorter period as may be fixed by the appropriate government, provided that subject to the approval of the conciliation officer, the time for the submission of the report may be extended by such period as may be agreed upon in writing by all the parties to the dispute.